Welcome, everyone. Thank you for attending today. This is the Center for Connected Health Policies Telehealth Policy Webinar Series, Court Cases. My name is Mei Kwong. I'm the Executive Director at the Center for Connected Health Policy. First off, if you require or wish to have closed captions, please note that we do have closed captions today. You just need to press the closed caption button, which you'll find on your Zoom toolbar. Next slide, please. Few disclaimers before we get started and a couple of friendly reminders. We asked that if you have any questions for our panelists today to please put it into the Q&A box. We also want to let you know that any information provided in today's webinar should not be considered legal advice or any type of formal legal opinion. We only are providing this webinar for educational and informational purposes. We suggest you contact legal counsel if you have a wish for a formal legal opinion. We also want you to know that should any company or product be mentioned, that neither CCHP nor I have any type of financial interest or arrangement or affiliation with such an organization. Today's webinar is being recorded, and both the recording and the slides will be available about 48 hours after this webinar. As I mentioned earlier, closed captioning is available, so if you wish to employ that, please press the Show Captions button, which is available on your Zoom toolbar. We also ask that you refrain from any type of political statements or advertising products or services during this webinar in the Q&A section. Again, if you have a question for our panelists, please put it into the Q&A box. And we also ask that you fill out the very short evaluation form that will be available after this webinar. You'll receive a link to that, and that would really help us out if you could fill that out. Next slide. A bit of background about CCHP. We were established in 2009 as a California telehealth policy organization as a program underneath the Public Health Institute. An opportunity to become the federally designated National Telehealth Policy Resource Center became available in 2012 through funding from HRSA. CCHP applied for that, and we've been serving in that capacity ever since. We also work with a variety of other funders and partners on the state and federal level. We also act as the National Consortium of Telehealth Resource Centers, which is made up of the 14 telehealth resource centers, 12 regional resource centers that cover specific states, and 2 national centers, one on policy, which is CCHP, and one on technology, which is located in Alaska. We also act as the convener for the California Telehealth Policy Coalition. Next slide. And this is a map of the telehealth consortium of telehealth resource centers. I really urge you and strongly advise that if you have questions around telehealth, to please contact your regional telehealth resource center. Next slide. For today's agenda, we are going to be covering what are the Loper Bright and Chevron cases and why are they important in the area of policymaking and how can they impact telehealth policy and what can we expect to happen next. Now, when CCHP decided to do the series of court cases, this was also with the understanding that some of these cases are very recent or are still pending. So we may not have exact answers right now. But we thought it was very important to inform the telehealth community regarding these court cases, which, while maybe not specifically about telehealth, could have an impact on how telehealth is going to be used. Next slide, please. And for today, we have a great lineup of speakers. It's going to be an exciting day and exciting and very educational discussion. Very quickly, we have Lori Garber from Foley Lardner, Leah Richardson, also from Foley Lardner, and Randi Seigel from Manatt Health, who will be our panelists today. We're actually going to start off with Lori, but before each speaker does their section, they'll be providing like a brief introduction of themselves. So Lori, can you kick us off, please?
Hi, yes, good afternoon, everyone, and thank you for joining us today. I am Lori Garber. I'm a partner at Foley Lardner. I have litigated Administrative Procedure Act cases for about 15 years, challenging agency regulations and other agency actions and decisions, although my practice is more broadly defending healthcare providers or otherwise advocating on behalf of healthcare providers against the government. So the government's on the other side and you're a healthcare provider, that's my practice. I'm going to start by talking about the APA and Chevron and Loper Bright, just to level set here. Next slide, please. So I'm going to get a little bit in the legal weeds right now, and I'm going to try not to bore people or make anyone's eyes glaze over, but it is important to understand sort of these foundational steps to understanding the rest of the webinar today and the context for the Loper Bright decision from the Supreme Court this year. So The APA is a statute that says a court must set aside agency action if it's not in accordance with law. So if you are a plaintiff, you can file a lawsuit under the APA asking the court to set aside an agency regulation, an agency decision, anything like that if it's not in accordance with law. I'm definitely oversimplifying. There's a lot of hurdles you need to get over to file an action under the APA, but that's the broadly speaking, that's what the APA says. Now, part of the APA says to the extent necessary, the court is to determine the meaning or applicability of the terms of the agency action. Sorry, I botched that. The court is supposed to interpret constitutional and statutory provisions at issue in the APA case. So what that means is thinking like zooming out and thinking about our general structure of government, right? Congress passes laws, executive agencies implement the laws, and the judiciary interprets the laws. So the APA is essentially saying the reviewing court should interpret the laws that are applicable. That brings us to Chevron, which is a doctrine that got developed in the courts, beginning with the Supreme Court decision in 1984 that really established this doctrine and this line of cases that came after it. So the Supreme Court case was the Chevron case in 1984. And essentially, it was interpreted to say that if a statute is ambiguous, courts defer to the agency's interpretation of the statute, so long as the agency's interpretation is a permissible reading of statute. And I'm going to unpack that just a little bit. So if an agency implements a regulation that's based on a statutory provision, and that regulation isn't clearly authorized by the statute, but it could be authorized by the statute, it's a little vague, it's a little ambiguous, courts were deferring to what the agency said, hey, this is a reasonable interpretation of statute, and it's the agency's interpretation, so defer to us. And courts were doing that for about 40 years under the Chevron Doctrine. That all changed with Loper Bright. So Loper Bright, this recent Supreme Court decision, said that courts need not, and in fact may not, under the APA, defer to an agency interpretation of the law simply because the statute is ambiguous. So that's the sea change here. And we can go on to the next slide. So you may ask, what does an agency interpretation of statute have to do with anything? So backing up here for those who may be less familiar with the rulemaking process here and how all of the different branches really work together, starting with statutes. So statutes are laws passed by Congress that set forth requirements for the federal healthcare programs, including related to coverage of items and services, how those items and services can be furnished, etc. And through those statutes, Congress authorizes agency action, which leads us to regulations. So components of the Department of Health and Human Services, such as CMS, FDA, CDC, implement the statutes. And the regulations reflect the agency's statutory interpretation. So if a regulation misconstrues statute, it could be invalidated under the APA. So, like I said, I've been litigating in this area for a long time. Chevron deference made it difficult to win APA cases. I have won them, and it's great because the odds are stacked against you when you file these cases because there's so much deference to the agency in a lot of instances. But because the agencies did not have to have the correct interpretation of statute or the best interpretation of statute, or even the interpretation of statute that the court would have, there was just so much deference to agencies. Loper Bright changes that and emphasizes, hey, it's up to the courts to decide statutory interpretation. And I'll note that it's not just regulations that are at issue here. So there's other agency action that can reflect agency interpretation, whether it's a decision by administrative, like an administrative law judge, or the Provider Reimbursement Review Board, or any other type of final agency decision that's also at issue here. And this really has implications broader than federal programs, because even though Loper Bright deals with federal law, A lot of states and a lot of private insurers tie requirements back to federal programs for lots of different kinds of healthcare services requirements. So this is beyond federal programs. Next slide. And this is my last slide before I turn it over for a bit to my other co-panelists here. So what'll happen now in the wake of Loper Bright? So courts may invalidate regulatory provisions that go beyond what the statute permits or that are based in an incorrect interpretation of statute. Now, this was the law before Loper Bright, but the new thing here is that courts can no longer defer to agencies on their reasonable interpretations of ambiguous statute. So we expect to see more invalidation, perhaps. Then I will turn it over to my colleague, Leah Richardson, to talk to us about what this means for telehealth under the federal scheme to start.
Good afternoon, everybody. Thanks so much for attending. My name is Leah Richardson. I'm also a partner at Foley Lardner. I'm a healthcare regulatory attorney, not a litigator like my colleague Lori, but I represent institutional providers, mostly hospitals, health systems, and those types of entities that do a lot of telehealth, and so advise on all of the statutes and schemes that we're about to talk about. So in order to understand what Loper Bright means for telehealth, we have to understand kind of what the statutory and regulatory schemes that underlie, telehealth services. And so from a federal perspective, there's really three kind of big buckets. There's the Social Security Act, which addresses Medicare reimbursement for telehealth services. And as many of you know, this part of the statute is very particular and very restrictive. So the statute says that Medicare will pay for telehealth services only if delivered in certain rural areas of the country, and only in certain locations. So the patient has to be in a hospital or a physician office, for example. That's called an originating site. There are a lot of restrictions on that. There are a few exceptions for certain, specialized services like home dialysis and stroke, et cetera. There's the Ryan-Haidt Online Pharmacy Consumer Protection Act of 2008. And that statute is also very particular in what it requires and what it permits. And it requires practitioners to see a patient in person before prescribing controlled substances, including medications to treat opioid use disorder, unless one of 7 statutory exceptions are met. So again, if we're thinking about Chevron and we're thinking about Loper Bright, we as regulatory attorneys would not consider these particularly ambiguous statutes. And then the last kind of statutory scheme from a federal perspective that has a nexus with telehealth would be the FDA regulatory scheme and statute. And it's actually mostly guidance that has a nexus with the FDA, with telehealth. So the FDA is empowered to regulate digital health and telehealth products through statute and regulation, but they generally take a very tailored and risk-informed regulatory approach, and they do it through guidance, and they focus on functionality of these devices and products that pose a risk to patient safety. So for example, the mobile medical app guidance and the medical device guidance. They also advise on cybersecurity and interoperability. So there's guidance there too. So those are the three kind of schemes with respect to the federal law. And remember that Chevron and now Loper Bright are federal cases dealing with federal authority. So they're very particular and very narrow in scope, really. Next slide. So if you recall, back in 2020, the CMS, in response to the PHE, expanded through waiver authority the availability of reimbursement for telehealth. But before that, CMS's regulations very closely tracked the statute which again is very restrictive and narrow. And so telehealth services would be reimbursed only if they were services that were conducted via audio video telecommunications technology. And again, there are restrictions on the originating site and the geographic location of the patient. The patient generally couldn't be in their home. You couldn't use phones to deliver telehealth services. You couldn't do telehealth service. You couldn't get reimbursed for telehealth services if it was audio only. And the list of telehealth services that were eligible for reimbursement were very narrow. And before the PHE, CMS started broadening the availability of what we call virtual care services. And CMS actually explained that these are services that are not subject to the telehealth statute, which again is very narrow, because these are services that would not normally be delivered in person, where the telehealth statute is related to services that would normally be occurring in person, like regular E&M visits. And so CMS created these buckets of services that could be reimbursable that were delivered via telehealth technology, like virtual check-ins and e-visits and remote patient monitoring. But there's still a lot of rules in terms of how you can get reimbursed, but they were created as a workaround to these statutory restrictions on telehealth reimbursement. Next slide. Next slide, please. So then the PHE was upon us, and CMS used its waiver authority. It's to waive some of the requirements related to telehealth reimbursement, and then in the years since has, through a combination of statutory action, so legislative action, through regulation, through guidance, has continued to expand telehealth flexibility. So there has been some changes in the rules. A lot of it, but some of it is only through guidance. So for example, and a lot of these telehealth flexibilities have been extended through the end of this calendar year, but would have to, there would have to be an additional extension through statute, or there would have to be actually a change in the statute, the Medicare reimbursement statute, in order to make some of these permanent. So for example, the in-person requirement for mental health services, they've delayed that in-person requirement for telehealth services furnished by RHCs and FQHCs. They've expanded the scope of originating sites where telehealth can be furnished, including the individual's home. They've expanded the definition of telehealth practitioner to include practitioners that traditionally were not permitted by statute to provide telehealth services, reimbursable telehealth services, including occupational therapists, physical therapists, speech language pathologists, etc. And then they've also continued the flexibility, the coverage of certain audio-only telehealth services. It's more narrow, but again, if you're thinking about the original Medicare statute, that would not have permitted audio-only services to be reimbursed. And next slide. And then lastly, we think about the DEA's extension of flexibilities under the Reinheit Act. So again, absent an exception, one of the statutory exceptions, practitioners had to have had an in-person visit in order to prescribe controlled substances to an individual. And that statute was created in reaction to a young man who had died as a result of a controlled substance prescription issued via telehealth to a practitioner that he had not met except for that one visit. And so initially, at the beginning of the PHE, the DEA granted a temporary exception to allow for the prescribing of controlled substances via telehealth, even when a practitioner had not had a previous in-person visit. And then in February of 2023, they wanted to pull back those temporary flexibilities, and the telehealth community had a pretty strong reaction to that. So in March, they issued a temporary rule, and this was a regulatory change. And so it's not a change in the statute, but a change in the regulation to allow to continue these flexibilities until 2020, almost the end of 2023. And then not long after that, they issued a second temporary rule, again changing the regulation, and those flexibilities are now through the end of this calendar year. So again, this is a regulatory change, but it is broader than what the statute, the Reinheit Act, would otherwise allow. And of course, everybody is anticipating further guidance on what the DEA will do after this calendar year. So that is the federal, generally high-level federal scheme for telehealth reimbursement and rules. And now I'm going to turn it over to Randi to continue talking about.
Hi, I'm Randi Seigel. I'm a partner at Manatt, Phelps and Phillips in the New York office. I'm a healthcare regulatory and transactional lawyer, and I work with a bunch of different healthcare stakeholders, including emerging companies, on navigating the telehealth and digital health landscape. So just to round out our discussion on sort of the federal enabling legislation that surrounds the delivery of telehealth, even though we think of Medicaid as a state-run program, there is federal legislation that enables states essentially to be able to offer and pay for telehealth within their Medicaid programs. And so unlike the Medicare reimbursement framework, the Medicaid authorizing legislation is extraordinarily broad and doesn't specifically address telehealth reimbursement delivery methods or criteria for implementing telehealth. And so under these rules, CMS has very broad authority to give states deference, essentially, to develop their Medicaid programs, which may include the delivery of telehealth services. So under the broad federal rules, as well as the implementing regulations, each state essentially gets to decide who is their Medicaid eligible groups, and the types and ranges of services and payment level for services, as well as administrative and operating procedures related to those services. So conditions of payment or conditions of participation in order to provide telehealth services. The enabling statute gives states broad authority to establish the amount, duration, and scope of each service, which would include telehealth services. Although, as I mentioned, telehealth is never specifically referenced in the enabling statute. So from a Chevron versus Loper, discussion, the Medicaid authority, like I said, unlike the Medicare authority, already gives this broad discretion to the states. However, in this new environment, under existing statutory authority, if CMS wanted to flip and, let's say, give a directive that all states must cover telehealth or mandate how telehealth must be covered, they would be unlikely to have that authority under the current enabling statutes, and certainly don't have that deference to make that determination in sort of this new environment. Furthermore, if states want to cover telehealth services, as long as they're provided at parity, reimbursement parity, meaning they pay the same amount as they do for inpatient services, states actually don't even need to seek approval for the services, and they don't need to list them in their state plan. If a state does want to pay for telehealth services at a rate different than in-person care, then the states must submit separate reimbursement. they must submit a SPA to indicate the reimbursement and get approval for those services. I also want to point out one other little nuance under the Medicare, the Medicaid framework with regard to sort of a telehealth limitation that exists in the federal enabling statute as well as within the regulatory framework. And so there is some language in regards to how services may be offered within a clinic under both the federal law and the regulations. And this provision has been interpreted by CMS to prohibit essentially the provision of telehealth services by something that's been labeled a clinic under the state licensure framework or within a state plan. And it would prohibit telehealth services from being provided by that clinic unless the provider furnishes those services is on site at the clinic. So a provider could not be at home furnishing services to a patient via telehealth under this interpretation. They would actually have to be on site at the physical location of the clinic. When we have advised clients about this, this is under the current statutory framework, a pretty conservative reading by CMS, and arguably CMS could have, but hasn't, taken a more expansive interpretation of the federal authority and its own regulations. Under Chevron, CMS probably would have had more deference to take such an interpretation if it could have been convinced to do so. But under the new Loper standard, CMS is more is probably highly unlikely to do so, and it would be more likely to be challenged. And with that, I'm going to tee it up to turn it back over to Lori to sort of talk about, put the context of what Leah and I have spoken about, put that into context of how Loper may impact telehealth specifically.
Yeah, thank you, Randi. Thank you, Leah. Yeah, so I think like going back to how to challenge how telehealth regulations programs may be challenged in court now, and what Loper Bright has changed versus not changed in terms of that landscape. So I want to start with what hasn't changed. So one is that provisions are probably safe until they're challenged and then either withdrawn by the agency or invalidated. So if CMS has some policy or regulation that may go beyond what the statute authorizes and no one challenges it and it doesn't make its way into court, my take is it's probably safe. And I will add to that, it's safe until it's actually invalidated, which would take a long time. It takes months for cases to work their way through court and get a decision. So you would have, I would say, a heads up if this were going to be happening or if this were a possibility. Next, what has not changed is the requirements to get to court and to have a viable APA court case have not changed. So when we think about the telehealth flexibilities in particular that a lot of industry likes, even if they go beyond statute and someone wants to challenge that, they've got to think through, do I even have standing to challenge this? Do I meet the legal prerequisites to challenge this in court? Which, like, if you're a brick and mortar health services provider, you can't just say, I don't like this regulation because it helps my competitor and it doesn't help me. That's not going to be enough to get you in court. So the bar to challenge these is not just, I don't like this, it helps my competitor, but it's higher than that. And really exhausting administrative remedies and standing could be a series of webinars in themselves. So I'm not going to go too deep into that, but just know it's not easy or quick to challenge these things. The next, so something else that hasn't changed is a lot of statutes delegate discretion to agencies. And if the discretion is clearly delegated to the agency, courts are going to continue to defer to the agency. So as my co-panelists have mentioned, for instance, we have the the declaration of the PHE, which came under statutory provision authorizing certain discretion to the secretary in a public health emergency. That's an instance where a lot of discretion has been expressly delegated to the agency. So CMS can do more, for instance, in that situation. There are other statutes that very plainly delegate discretion to the agency. So y'all may be getting a sense that these cases are so specific to the regulation and the context and the statutory provisions that may or may not authorize the regulation, which makes this a really complex area of law, although it has gotten more fun post Loper Bright. A few more points on what hasn't changed. So I really want to draw a line here. So what's changed is deference to agency interpretation of statute. What has not changed is the standard of deference to agency interpretation of the agency's own regulations. Where appropriate is my caveat. This is a whole nother line of cases that is also constantly evolving, and that's not at all affected by Loper Bright. Again, could be its own webinar. Deference to agency fact-finding, still intact. Agency policy decisions, still intact. So for instance, if there's a case that's before an administrative law judge and there's fact-finding involved in terms of what a provider did or did not do, or whether they followed requirements correctly, and it's really a fact-finding exercise, depending on the statute, that's very likely not going to be something that a court would look at fresh. There's still deference to the agency there. And similarly, in this last point, this is something that the Supreme Court pointed out in Loper Bright, that when you're in court, the agency is free to argue for their statutory interpretation and say, like, look, judge, we really know this area of law. We really know the complexities here. This is what Congress meant. This is how this statute is supposed to be read. And the court may be persuaded by that. I think it's a tricky line because it's no longer like you can defer to the agency just because they are the agency. But I think you will see courts, particularly those courts in my home city of DC, continuing to offer some, I don't know, informal deference might be the wrong word, but give a lot of thought to the agency's views from that perspective. So that's what hasn't changed. Talking about what changes are expected. So we are expecting more challenges to regulations and other agency action, given that Chevron's gone and we're no longer deferring to the agencies. I think these are going to be both affirmative and defensive. So we'll see more people bringing challenges under the APA, seeking to invalidate agency action. We'll also see more entities using Loper Bright defensively. So for instance, a lot of my practice is protecting clients against False Claims Act investigations and litigation. And I think we're going to see defendants and investigation targets start to argue, okay, DOJ, you're saying you think we violated these regulations, but these regulations are invalid because they go beyond what the statute says. So how could there be a False Claims Act case here? We don't know yet the viability of those arguments or how courts are going to look at them, but I certainly expect we'll be seeing them. As I've mentioned before, these cases are, I'm not going to say easy to win, but will be easier to win than they were in the Chevron era, where agencies just got so much deference. We're also expecting HHS to have less latitude when it goes to implement new requirements or programs. Like, they are going to think more about whether it's expressly authorized by statute. They don't like how often they get sued on rulemaking, and it's just going to increase after this court decision. So HHS not only has less attitude, but we expect they will also act more cautiously and go through rulemaking even slower than they already do, in light of trying to be really careful and making sure that they're falling in line with what the statute has authorized. There's also, as you may imagine, a risk of inconsistent judicial interpretations. So this is tricky here because when a judge is interpreting statute, there's all of these traditional tools of statutory interpretation that the courts use to try and figure out what a provision that seems ambiguous should mean or could mean, or what the best reading is. And you could have a hodgepodge across the country of judges saying different things, which is different than pre-Loper Bright, where the agency would say, this is the agency's position. I'm HHS, and this is my position, regardless of what jurisdiction you're in across the United States. What's changed now is a judge can say, okay, in DC, this judge agrees with the agency's interpretation, but in the Northern District of Texas, the judge does not agree with the agency's interpretation. And what are you going to do then? Well, that's the type of case that can work its way up to the appeals court and ultimately to the Supreme Court, and potentially could cause some confusion, maybe a little bit of chaos as we're trying to sort out what requirements are not still in place. Judges also have the authority when they interpretations, the judge will say what that means, like what the next step is in the case. And a lot of times they will restrict their ruling to just their jurisdiction, or it will be nationwide. So we'll have to watch this closely to see how that develops. But the cautious approach that I would probably advise my clients is assume it's the law until it's invalidated and clearly invalidated as to you. If it's not workable from a business perspective, consult a lawyer, talk through it, really understand the risk and the landscape. Another change that I would expect is more express statutory language giving discretion to agencies. So as we've talked about, there's already current legislation that clearly delegates discretion to agencies on taking certain action, making certain policy decisions, and the like. I think Congress would be wise to either make sure that they're not being ambiguous, which I think is very hard for Congress to do, or just be clearer where they're affording discretion to the agencies, rather than assuming that the agencies are just going to fill in the gaps like they were able to do in the Chevron era. Next slide. Okay, great. So I will turn it back to Randi to talk us through the this from a state laws lens.
Sure. Thank you so much, Lori. And to talk about things that immediately are not going to change at the end of Loper, just to sort of level set for everyone on the call, is that while federal legislation may drive Medicare reimbursement, Medicare generally defers to state law in terms of licensures and scope of practice, in terms of what services can be provided. And states also have to establish sort of fundamental rules around what constitutes a patient-provider relationship, what consents might be needed, and those requirements are payer agnostic. They really pertain to the professional's delivery of services. And the majority of the complexity around telehealth regulation and what makes it sort of challenging for companies looking to scale across state lines or expand their reach is that each state is sort of its own, has its own framework around how telehealth may be delivered in that state. And so states define what types of providers may deliver telehealth services within the state. Where generally a provider must be licensed to practice where the patient is located. There are some exceptions to this in certain states, or a more expedited pathway, but in general, and the requirement is that the provider be licensed. Some states obviously enable providers to practice across state lines via licensure compacts, but those still are adopted at the state level. So far, there's been no federal legislation essentially that says, you must honor reciprocity or allow providers to practice across state lines. Similarly, each state defines the scope of practice for a provider, so whether a nurse may provide telehealth services and what that might look like, or whether a dietitian's provision of services via telehealth They also require what might be necessary to establish a new patient relationship, including maybe what types of consents must be provided, what types of disclosures may need to be provided before you can have that patient encounter via telehealth. States also may limit modalities. So the way they define what telehealth is may be limited to video visits or asynchronous telehealth, but may or may not include audio-only videos or chat functionality or questionnaires. And to the extent that there is sort of telepharmacy happening, states also regulate, pharmacy prescribing requirements, dispensing requirements, and just to flag that even under, if the DEA flexibilities continue, some states still impose more rigorous requirements on prescribing and dispensing controlled substances within the state, which still may require potentially an in-person encounter unless those state laws are adjusted. If that's not complicated enough, as you know, if we flip to the next slide, states also layer on top of that the Medicaid reimbursement landscape. And so a provider may have authority under state law to deliver telehealth services, but that doesn't mean that Medicaid is going to pay for it. And so as we discussed earlier, states have pretty broad authority with regard to covering telehealth services, but not all states cover telehealth services in their Medicaid program the same way. As of March of this year, all 50 states in the DC Medicaid's program do cover live video telehealth, so video audio telehealth. Many states the majority of states cover audio only telehealth. A fewer number of states, but still the majority covered store and forward, which is asynchronous technology, but may define store and forward very differently. Each state's definition of store and forward may differ in terms of what might be required to constitute a store and forward. And then about 37 states cover remote patient monitoring to some degree. If we flip to the next slide, just to sort of further make our jobs in high demand as lawyers who work in the telehealth space, is that commercial payers may have a slightly different approach to reimbursement within each state. It may differ from what Medicaid covers, and they may impose potentially additional requirements related to coverage of telehealth and the modalities that might be covered and the types of providers that might be covered, as well as whether there's payment parity, which means that the commercial payers are going to pay for the service at the same rate that they would pay for in-person care. And sort of the complexity of this landscape and sort of the state policy framework, which is sometimes statutorily driven, often regulatory driven, and more often than not, sub-regulatory guidance driven, that won't necessarily be immediately impacted by Loper. But I'm gonna turn it back since we have Lori to talk through how Loper might potentially influence state telehealth policy.
Thank you, Randi. Yes, so as we've talked about, Loper Bright is a federal court case affecting federal administrative law. So it doesn't directly impact whether state courts defer to state agencies on interpretation of state law, because every single state in the United States has different laws in terms of their administrative scheme. So this really varies by state law and how the state courts have interpreted state law to date. Prior to Loper Bright, there was already a patchwork. So some states permitted or required their courts to defer to state agency interpretations of statute, but at least a handful of states did not permit their courts to defer to state agency interpretations of statute. So before Loper Bright came out, there was a lot of speculation that the Supreme Court was going to get rid of Chevron deference. The Supreme Court had not relied on Chevron deference in a number of years. And there was speculation it would go away, and there was speculation there would be chaos. But then you had a bunch of people saying, well, there's a handful of states here that got rid of deference, and it's not that chaotic. Now, I think it's yet to be seen what happens at the federal level. But there were states that already had a scheme like we are in today, where there's no deference to agency interpretation of statutes. It's really been a patchwork. Now, some states that did or do defer to agency interpretation of statute were following federal law when they made that determination in their case law and otherwise. So we could see a trend where more states start following suit the other way, given Chevron deference is now gone at the federal level. But there's no requirement or legal mechanism or anything that's making states follow federal law on the deference or no deference front. One more note on how this could all interact with the state level deals with Medicaid. So if, as we talked about earlier, when a state wants to make certain changes to Medicaid plans, they have to submit a state plan amendment, sometimes fondly referred to as a SPA. And HHS has to, at the federal level, approve those state plan amendments for certain things. Those approvals by HHS of state plan amendments are subject to challenge under the APA. So if there's a statute, like for instance, in the Medicaid implementation statute, if that contradicts something that's in the Medicaid state plan, a party could challenge that HHS approval of that state plan under this new no deference scheme and perhaps have success. I mean, I've litigated a scenario like this before Loper Bright, where we got a state plan amendment approval by HHS vacated. So it's something that has and does happen. Although in the telehealth context, it might be tougher because there's a lot of tougher in a good way for the telehealth industry, because there's just a lot of discretion that filters down to the states on these topics. Then our next slide is we are each gonna give a telehealth prediction in this new world. So let's start with Leah.
Yeah, so and I see the questions coming in, and maybe this will answer some of some of the questions, or at least in part. I think that I implied that there was a lot of kind of expansion that was CMS and DEA in particular. And I don't want to say that's inconsistent with the statute, but the statutes are very particular, and there has been a lot of expansion that for telehealth reimbursement and other kind of activities related to digital health. And I think the agencies have generally been very generous in that regard. And so I think if we're thinking about telehealth, or let's think about just Loper Bright and what is most likely to be challenged. I think it's agency action that's not provider friendly, that's generally more restrictive. And I think with respect to telehealth, I think the agencies have been quite generous and have used the authority that they have to really expand the availability of reimbursement and the activities that are happening via telehealth. So I'm not sure we are going to see a lot of challenges to this agency generosity, as we're calling it. There is one question from my friend Cindy Weisner, who's asking, well, is there likely to be more agency emergency action and challenge to that? And I think perhaps, because I think we are well beyond the public health emergency. And so query how much the agencies can continue to rely on that expanded, authority, the emergency authority. I mean, there's some expansion has been done by statute and regulation, but some has not. And so if they're going to continue to rely on kind of emergency authority, I think that certainly could be ripe for challenge theoretically, but I guess the question is who's going to challenge it. As Lori mentioned before, you have to have standing to challenge agency action. If it's very generous, the providers are not likely to challenge it. And so like Lori was saying, well, maybe someone who's harmed by it, but then it's very hard to kind of establish standing in order to challenge agency action. So this is one of those things where I think we're just going to have to wait and see what happens. So I think Randi's next with her prediction.
Yes. Thank you. So if we had a crystal ball and we're going to make a prediction, this could incentivize Congress to finally act to amend the Medicare statute to remove the limitations on telehealth so that CMS can make permanent a lot more of its flexible coverage. And it's possible that this could cause Congress to take action because telehealth is really not a bipartisan issue and has been pretty much widely supported by healthcare stakeholders to continue access and reimbursement for telehealth services. And patients, including Medicare beneficiaries, many of them want care to be delivered this way. So this might be what was needed to get Congress to finally move. In addition, because pointing out that CMS has used also some creative definitions to provide coverage for communication-based technologies and services like e-consults, which many states and probably most of us on the call likely consider telehealth, to take it outside of some of these congressional limitations. CMS could potentially see that some of these types of interpretations could be at risk under Loper. And so they may also be, more aggressive is not the right word, but inclined to try to encourage Congress to take action so that these additional services, which have sort of been carved outside of the definition, which might be a stretch in terms of statutory interpretation, are not potentially walked back in the event that there was a challenge. And Lori?
Yes, lastly, just a reminder when we're talking about predictions. So states and private payers, as I think Randi mentioned, do not just follow the federal government, right? I mean, it's a hodgepodge. They don't like to make it easy on us and just say this is the rule everywhere across all payers. That is far from the case. However, there are a lot of state programs and commercial plans that follow Medicare guidance and Medicare rules in part or in whole. And so we would expect them to, or many of them, to potentially follow the trends at the federal level. So that is our final prediction. I think that concludes our prepared remarks. I know we have a lot of questions in the chat window, which looking at the questions really exhibits just like the broad nature of how broadly applicable all of this can be and how many of these questions will require like a deep dive in themselves and don't have easy answers. But let me turn it back to you, Mei, to MC next steps.
Well, first off, I just want to thank you all. That was wonderful. Great overview, great detail in there as well. I learned a lot, and I'm sure our attendees did too. I do see some hands raised. That function, we don't have like audio function, so you'll need to type your question into the Q&A. But there are a couple of questions in here that I thought, see if we can like dig a little bit deeper in here. So as you probably saw if you were looking in the Q&A, a couple of questions have propped up around Medicaid and like, where that kind of influences. And Randi, you had mentioned something in that there's broad flexibility given to the states to decide how to structure their Medicaid program, how to decide their telehealth policy. So in a way, CMS may be facing a Loper challenge if they try to get too prescriptive with telehealth and the Medicaid programs of saying like, well, thou shalt now do X with telehealth. So that's actually probably something CMS will not likely do in the future, given like the Loper Bright decision. But a question that come up saying like, well, yes, there's differences in Medicare and Medicaid, but what happens if you got a dual eligible? Like then, so does Loper kind of come into play in what CMS is telling like the states to do when you have like dual eligibles involved in like this whatever like kind of regulation or you know rule that they put down onto the states?
I can sort of start just to sort of unpack that a little bit. So for dually eligible, and just to clarify what that means for everybody in the audience who may not know, it means that the patient is covered under Medicare and then also covered under Medicaid. It often means that Medicaid is going to pick up the cost sharing of the Medicare services, as well as Medicaid often offers a more robust set of services for long-term care services and or more robust coverage, as we talked about, for telehealth. And so the way that it works from a reimbursement perspective is that Medicaid is always the payer of last resort. And so for a dually eligible beneficiary, reimbursement and coverage is first sought from Medicare. If Medicare doesn't cover it, due to, let's say due to the limitations, or because they haven't, they don't have flexibilities in place for this particular type of service, then the coverage would flip to Medicaid, and the Medicaid would pick up covering that telehealth service under its own state plan and reimbursement framework, and those requirements would apply. And so the way that I would interpret Loper to apply, it's sort of exactly like how we bifurcated the presentation, is that if there is a challenge to the Medicare authority, then whoever has standing could bring a challenge to CMS's action under the Medicare authority. But any sort of challenge under the Medicaid authority would be a totally separate, challenge under a different statutory authority, for which we know that CMS has much broader authority. So it might be depending on what the challenge is, it might be a harder challenge, because the statute makes clear that CMS has tremendous deference to develop the Medicaid benefits. Lori, did I botch that? Leah, anything to add?
I agree with that. And I think I was thinking through the context which that may come up, right? Like if a provider has a claim denied for their dually eligible beneficiaries for a certain, maybe it's a recurring issue, and they appeal that perhaps to an ALJ, and it works its way through the ranks, and then you're in court over it. I could see there being a challenge there, but whether or not it's viable would really depend on, is it really going beyond statute? And if there's a lot of discretion involved that's granted by statute, it's not that likely to be successful. But I thought that was well said, Randi, just playing out an example.
All right, we have time for just one more question, and I'm probably messing things up, picking probably kind of a complicated question. But someone asked your thoughts on the legal challenges to some of the HIPAA rules that have been issued recently in recent time around reproductive care privacy. Like, how does Loper play in with some of those types of things that were issued before the Loper Bright decision came out, but were done through a regulatory process, or again, like maybe perhaps guidance from OCR that came out? So any thoughts on that? It's a complicated issue, yeah.
Well, yeah. Well, I mean, it's a good question. It's a federal statute. It's again particular, but the regulations do kind of fill out a lot of put a lot of the meat on the bone. I'm not recalling that particular issue is addressed by statute, right? So the question would be, in promulgating regulations related in particular to women's health and guidance, whether they have the authority to regulate in that space, and whether that is you know, permitted by statute and whether that's the best, you know, reading of the statute to regulate in that way. So that's a very good question. I mean, I do think that OCR, which is Office for Civil Rights, that enforces and oversees the HIPAA scheme, does also have broad authority to regulate in the privacy and security of protected health information.
Yeah,
So,
I would add one more thing to that. I think if you actually look to the preamble of in the proposed rule in particular, and then a little bit in the final rule, but I think OCR anticipated that challenge, and they basically lay out in many, many pages of commentary why they think they have this authority and why it's very similar to other ways, in particular psychology, psychotherapy notes, why they have this authority. So if you're interested in the weeds, you can sort of see them preemptively writing out how they would respond to such a challenge.
All right.
Right.
And on that note, we are at the hour here. So as the slides are being brought up, again, I just wanted to like reemphasize that this is a brand new decision. It just came out in June. So there's still a lot of unanswered questions here, but we want to thank our speakers for providing like, you know, their great knowledge, their great insights into like where this case may take us, at least in the telehealth realm here. So once again, I want to thank Leah Richardson, Lori Garber, and Randi Seigel for this great day of, you know, a great webinar here of all this information. I'm sure our attendees greatly enjoyed as much as I did. If we can go to the next slide. Saw a couple of questions in the chat asking if a recording and the PowerPoint will be made available. They will be made available. Wait about 48 hours, and then you can go to our CCHP website to the resources page. There's the QR code if you want to just go ahead and snap that now, just to have that handy. If we go to the next slide. Know that the next webinar will take place on October 3rd, and it'll be focusing in on cross-state licensure and court cases surrounding that. Now, just a fair warning, those court cases are still active now. So unlike the Loper Bright Chevron webinar that we had today, those have not been decided yet. So it is still a little bit of a, we're not quite certain where this may be going if the case is not decided yet. But if you are interested in attending that webinar, it will take place on October 3rd. Again, a QR code for the registration link there. Next slide. And once again, if you could just fill out the very short evaluation form that you'll get as soon as you log off here, that would be really appreciated. Thank you once again to our panelists, terrific webinar. And also thank you to our attendees. I hope everyone has a great day and happy Labor Day as well too. Stay safe, everyone.